Good afternoon, members. Welcome to the meeting of the panel on Administration of Justice and Legal Services. I now call the meeting to order. Information papers issued since the last meeting. First of all, CB bracket 41263/16-17 bracket 01. Information paper entitled Review of Financial Eligibility Limits of Legal Aid Applicants provided by the Home Affairs Bureau. Another paper is CB bracket 41275/16-17 bracket 01 from the Department of Justice, an information paper entitled Arrangement on Reciprocal Recognition and Enforcement of Civil Judgments in Matrimonial and Family Cases by the Courts of the Mainland and of the Hong Kong SAR. Dr. Fernando Zhang wrote to us after the last meeting, and he would like to have a meeting arranged on the latest developments concerning legal aid, but we have only just visited the topic not too long ago. So I suggest that his proposal should be included in the list of outstanding items so that in the coming year we'll look at the matter again, namely legal aid. And then items for discussion at the next meeting, please refer to CB bracket 41255/16-17 bracket 01 and bracket 02. We are going to hold our next meeting on the 18th of July, a Tuesday. Please mark your diary. It is a Monday. It is a Tuesday at 4:30 p.m. As to the items for discussion, we have the following. First of all, provision of legal advice services for persons detained in police stations, the rule of law and the role of the prosecutor. Progress of work of the Interdepartmental Working Group on Gender Recognition, and then measures to prevent the misuse of the legal aid system in Hong Kong and assignment of lawyers in legal aid cases. Regarding the first proposal, the Legal Aid Services Council has completed a study regarding the provision of legal assistance to detainees. The Home Affairs Bureau would like to give us a briefing. For the second item, the Department of Justice has suggested explaining to members its standard practice and policy in handling prosecution after the case is submitted to the DOJ by the law enforcement agencies after investigation. For item C, at the meeting held on the 18th of October 2016, we decided to include the issue of the progress of work of the Interdepartmental Working Group on Gender Recognition into our list of outstanding items. We'll invite the DOJ to report on the progress. As to the fourth item, again, at the meeting on the 18th of October 2016, we have expressed our concern on the need to prevent the misuse of the legal aid system in Hong Kong, as well as the assignment of legal aid lawyers. So members, do you agree that we should also extend our meeting until 7:30 so as to accommodate the discussion of four items? If you do not oppose, then I assume that you find it agreeable. Next, I would like to remind members that in accordance with Rule 83A of the Rules of Procedures, if you have any direct or indirect pecuniary interest in relation to any item to be discussed today, please disclose the nature of the interest before you speak. Now we come to the discussion items. First of all, legal education and training in Hong Kong. I think you have received this paper, CB bracket 41255/16-17 bracket 03. It's a paper from the Administration on Legal Education and Training in Hong Kong. We have also got paper CB bracket 41255/16-17 bracket 04, a background brief by the Secretariat. And then we have 1255/16-17/08, a submission from the Law Association of the Hong Kong USU. I would like to invite the Department of Justice, the Hong Kong Bar Association, the Law Society of Hong Kong, and then a number of deputations to join us. So please invite the deputations to join us. And they are respectively the 3 law schools representatives as well as the student union representatives. I would like to welcome the Secretary for Justice and would like to welcome the Bar Association representative, the Law Society representatives, representatives from the 3 law schools, and student union representatives, and also representatives from the Xuyan University. You can put on the earphone and you choose the right channel. Channel 0, the floor, Channel 1, Cantonese, Channel 2, English, Channel 3, Putonghua. If you need any assistance, please ask for help from our staff members.
If you need the simultaneous translation. 我首先呢，亦都提醒各位人士。
I would also like to remind attendees, when you speak, you will not be protected by the privileges and exemptions under the Electrical Powers and Privileges Ordinance.
The 3 law schools and from Xuyan University. For the need of translation, you may use our microphone. We have the services for English, Cantonese, and Putonghua. Okay? Thank you.
I would like to draw attention to the following. For members of the public who attend meetings in our electrical complex or who are sort of in attendance in the public gallery, there are points to note, and in fact a copy has been tabled in front of you on your desk. You may also want to get a copy from our security guard if you want to have a copy. First of all, I would like to invite the Secretary for Justice, Mr. Lim Si-yun, SC, to brief us on the latest progress concerning the comprehensive review on our legal education and training in Hong Kong. Secretary. Thank you, Chair. The DOJ is a stakeholder and also an employer of the legal profession. All the time, we have been very concerned about legal education and training as well as the related matters. For legal education and professional training, well, we are providing professional service. We are also having a direct and indirect influence on the rule of law.
Therefore, DOJ had supported the judge, Mr. Chan Siu-hoi, in his work as the subcommittee of legal education and training, and they have conducted an overall review, and we will call it the comprehensive review from now on. So in 2013, the Law Society represented had presented their CEE proposal. They had looked at the qualifications of the needs and requirements of Hong Kong law students, and the overall review ambit is already included in the DOJ paper in paragraph 4. The DOJ in the subcommittee has a representative, and they are aware that the comprehensive review will not just be looking at common entrance examination or the admission and recruitment of PCL students. On the contrary, the comprehensive review will look at legal education and training system in Hong Kong and all relevant issues. The details are in DOJ paper paragraphs 10 to 15. The DOJ supports the subcommittee's work, and in 2015 March they had provided funds of 1.5 million to support the subcommittee in retaining consultants to conduct the comprehensive review. The DOJ understands that the relevant stakeholders includes the legal profession, the legal schools, this panel, and the public. They all are looking forward to the subcommittee's recommendations, and we are also concerned about the overall progress. So as we say in our paper, the progress of the comprehensive review, there are, because of the reasons in paragraph 9, we have some falling behind in its work, and we understand that the subcommittee chairman hopes that in the second half of the year can provide the interim report and also conduct the second round of consultation and also publish its final report by the end of the year. The DOJ will continue to work with the subcommittee, and we hope that the subcommittee can conclude its review. The overall review purpose is to look at how we can further enhance Hong Kong's legal education and training. We want to ensure that the graduates can overcome the challenges that they will encounter at work, and we also want to provide high quality of legal services to the Hong Kong public to maintain Hong Kong's overall competitiveness, and also we want to ensure that Hong Kong can maintain its position as a legal arbitration and mediation center in Asia. So once again, the DOJ feels that any review or reform of the legal education has to be based on public interest, and we should not only just look at the individual stakeholders' interests. Legal education and training is not tailor-made for, or it does not serve the industry. It has to serve Hong Kong's public and public interest. So DOJ is very willing to share its views and also make proposals. Thank you, Mr. Rimsky-Yun. Next, we would like to invite the Bar Association, Mr. Chen Gingseng, to share his views. Thank you, Chairman. The Bar Association doesn't have any new position to provide because during the last meeting nothing had occurred. So even though we are aware that the Law Society and the 3 universities say they have some communication regarding proposals on the CEE, but in fact the Bar Association did not participate in the meeting because of objections from the Law Society, so we didn't know what had occurred. But regarding legal education, we do have the following viewpoints. First, if the 3 universities recruit PCL students, and if you require a uniform standard, I think we need to consider some practical issues, because applications to the PCL are not just from the 3 universities. We also have a lot of overseas applicants, and of course universities have different standards, they have different curriculum. So if we are to have a uniform recruitment standard, then we might need an admission test. But if we are to provide an admission test, we have to consider some practical issues, because in general the universities, when they take the final test, it will be May or June, and PCLL starts in September. So if you want students to take an examination, so from the practical point of view, we have to consider the timing, and the Bar Association also does not wish to see a student take too long before they can practice. If you require that they can only gain admission a year later, then the whole training process might take too long. And for those interested in the legal profession, that it would be a negative impact. So if we are to have a uniform test, we need to consider the practical issues. And we also have to consider the curriculum, what should be tested, and it needs further study. But regarding the CEE question, so even though it affects solicitors but not barristers, but barristers have two concerns. First, if there is an independent CEE issue, and if the CEE is another route to join the profession, then for PCLL students, will it affect, I think it would reduce admissions to PCLL. So, but universities need to have a critical mass for PCLL courses. If there are too few students, there might be some difficulty with the universities, so we have to consider that. So, when universities provide PCLL courses, student enrollment, that would affect the barristers, because the barrister qualifications, they have to pass the PCLL. So aside from that, if the CEE is to be considered as a test above, on top and above of the PCLL, we would like all barristers to join the field out of their own volition. It's rather than having failed a certain test and then being a barrister reluctantly. So we need to consider that. So even though the CEE, it seems to affect only solicitors, but there is a common PCLL course. We also have to consider students' attitude. It will affect barristers' interest. So when you consider public interest, we need to consider these factors as well. That's all I wish to say at this point. Thank you, Mr. Edward Chen. Next, we'd like to invite Mr. Hong Wan-sun, from the previous chairman of the Law Society. Well, the first comment regarding the Bar Association, I think the Bar needs to consider the development in the next few years. I heard that the CEE might affect barristers, it might affect the students, but the Bar Association, they can use their own methods and resources and ensure that when students choose to be barristers, they can maintain the current standards. Now, regarding the CEE, I don't have new information to report, or the reason is that we're at a stage where the Law Society has a final draft for the CEE syllabus. So, in my mind, our Legal Education Committee, when they have made a decision, these documents will be submitted to our standing committee, and we can wait for their feedback, and then it would be submitted to the standing committee. So if they can endorse the blueprint, then I would like to consult the 3 universities and other stakeholders regarding our blueprint, We'd like to know if there are any matters that are not feasible, and I'm very willing to hear feedback from other stakeholders. And I hope that by end of the year, the final report can be submitted to the 3 universities and other stakeholders. So even though I said that we'd like to see the CEE implemented by 2020, but I'm willing to give the universities more time to prepare. Chairman, that is what I wish to say today. I know that the previous chairman, Mr. Dieter Ye, would also like to speak. I'd like to provide some supplement to the points made just now. Regarding the CEE being another alternate route to joining the profession, the Law Society had never conducted a specific study. When we looked at the CEE, we had required all the students to take the PCLL first before taking the CEE. But if the market has a demand, in principle, the CEE can operate at that can serve that function. But currently, the Law Society has not considered that. At the current state, the Law Society focus is on working with the 3 universities and drafting the CEE. So the first step is that we will hope that the CEE can be incorporated into the PCLL, so students don't have to take an extra test. Second, whether if students fail the CEE and what profession they would choose, well, of course, each student's choice there are many choices in front of them. They don't have to join the barristers. For example, a lot of students after graduating from the LLB, they have not taken the PCLL. They also do a lot of paralegal work in law firms. So there are a lot of options. They can serve as in-house lawyers or other law-related work. Thank you, Mr. Ye. I'd like to, in our panel, we do have a lot of questions, but we do have a public participation. So we'd like everybody to keep their speeches in one language to facilitate communication and also to make it easier for our interpreters. We also have members of the public, we have parents or employers, so could you consider keeping a technical jargon to a minimum? We are constrained by time, and this is a very popular topic, so I'd like everybody, if you have long written questions, you can simplify it and report to our panel or highlight your most salient points.
In addition, just now when you came in, maybe a few of you haven't heard about my reminders, and that is for what you speak about you will not be covered by the Electrical Powers and Privileges Ordinance in relation to the exemptions and the safeguards. So please be reminded of that. Next, I would like to give the floor to the representatives of the law schools as well as the student representatives. Before you speak, in fact, I need to declare In fact, I've teaching at the Faculty of Law of the CTU, and my PCLL program was with the Hong Kong U, but I am not teaching PCLL program. I'm teaching the undergrads. First of all, I'd like to give the floor to Professor Michael Ho, Dean of Faculty of Law, Hong Kong U.
Thank you, Madam Chairman. Because time is short, I will limit myself to making 3 pleas here. The first plea is in line with what the Secretary of Justice has just said, that we have spent a lot of time, a lot of ink has been spilled on servicing the comprehensive review. Yeah. And my first plea, therefore, is that no significant decisions be made until we see what the comprehensive review report turns out to be. Yeah. Otherwise, there'll be a lot of expertise, a lot of time wasted. Yeah. These are experts which all the stakeholders see to be recognized in their field. Yeah. So I think their views should command a very high degree of respect. Yeah. My second plea is with respect to another study which the Law Society commissioned. Yeah. The Law Society, I think in 2013, yeah, between 2013 and 2014, commissioned an expert panel, yeah, to study roughly the same issue. Yeah. To my knowledge, the report has never been released. Yeah. So my second plea is that in the interest of having as much information as possible so that we can make the best decision possible, yeah, if I may ask the Law Society to consider or reconsider releasing either all or parts of that report. Yeah. And my third plea is actually in support of the written submission of the Hong Kong U Law Association, yeah, with respect to the retrospective application of any changes to current students. Yeah. May I make the plea then, the third plea, that whatever changes that we make should not affect students who are already in the LLB or LLB double degree program. Yeah. Thank you.
Okay. 多謝 Professor Ho， 多謝何耀明教授嚇。跟住落嚟，我哋請盛。
Thank you, Professor Ho. Next, Professor Lin Feng, Acting Dean, School of Law, CTU.
Two brief points. The first point I want to make is I agree with what the Secretary for Justice has said, that the public interest should be the sole criteria in conducting the legal education reform or review. And also the standing committee should be the most appropriate place for conducting such reviews, because all stakeholders have representatives there and views can be discussed and a consensus can be reached there if possible. And the second point I want to make is I've read the paper and I've seen there's some discussion about the unified entrance exam to the PCLL. That's something, as far as I can recall, we've never discussed at any occasion we're going to do that. So I don't know why suddenly we come to have this issue has been raised. Because after studying for 4 years, all students, then suddenly getting a law degree, then you ask them to sit an entrance exam into the PCLL. That would be extremely difficult and won't achieve any purpose at all. So we are really against that. We don't think that will achieve any purpose. As to CEE, because we are still waiting for the proposal from the Law Society, and I think we do hope we can get engaged as soon as possible, so then we can have a sort of dialogue and reach a sort of a proper conclusion on that. And the final point I want to make is with regard to the growing demand for PCL places. And actually, I think all 3 law schools are making an effort. Take us, for example, and last year, because of the double cohort, we increased the intake from 170 to 210. And this year, we are going to maintain 210, so to cater for the growing demand for the PCL places. So that's all I want to say. Thank you, Chair.
好，多謝林峰教授。
Thank you, Professor Lin. Next, from CU Hong Kong, I would like to invite the professional consultant, Mr. Christopher Knight, to speak.
It's your turn, yeah.
Thank you, Madam Chairman. Yes, I would also echo those views that we would not want to see any substantive change until we have seen the results of this comprehensive review. It's correct to say that public interest is at the heart of this issue, and I think it's in everyone's interest, the public interest, that we await this review and study its findings very closely. As an institution, we're not convinced there is actually a need for this common entrance exam, so we would like to study the results of the review in detail. I'd like to say that at all times we've been ready to discuss with the Law Society the practical implications of what they are proposing, but we haven't heard from them in the past few months, and we remain eager to try and cooperate in whatever way we can to discuss the practical arrangements and to know what their plans are, what they have in mind. Thank you.
Thank you. Thank you, Mr. Christopher Knight. And then I think we would like to hear from the other deputations. Say, for example, the Associate Head of Department, Dr. Claire Wilson from the Hong Kong Shiyan University.
First of all, thank you for the opportunity to be here. We're not a law school, and therefore we'd like to just provide a short background as to our institution, because we offer an alternative route to qualification other than the LLB. So Shiyan University is the first private funded university in Hong Kong, and the Department of Law and Business provides a Bachelor of Commerce degree in law and business. Approximately we have 60 students which are admitted each year, and the first cohort graduated in 2011, so we're relatively a new program. With regards to the structure of the program, all of the students are required to study the basic core courses from contract through to criminal law. Other discrete courses are also available, such as commercial law, banking law, finance law. The law element combines roughly 50% of the program, and the remaining 50% is made up of business core and elective courses. Now, while some of our students are attracted to the program due to its disciplinary approach, many of our applicants haven't actually met the required grades for admission to the LLB, and they look to the BCom as an alternative route to eventually being admitted to a solicitor or barrister in Hong Kong. Essentially, what they're looking for is a second chance. So during the first few years of our program, only 1 or 2 students were admitted to the PCLL. Now the number has increased, but not significantly. Last year we had 5% of our graduates who are admitted to the PCLL. In total, 19 of our graduates have been admitted to the JD. Now, we have 1 graduate so far who's qualified as a solicitor. 2 others will follow shortly. So we are making steps, but these steps are very short steps. Now at this point I turn to looking at alternatives to legal education which allow for providing opportunities. So with regards to providing opportunities, our institution supports proposals that have been put forward to ensure that more opportunities are available for those candidates who are deserving. The harsh reality is that there are candidates out there who have the potential, but they've slipped through the net. Those who have the means, they can pursue qualifications in other countries. But for those who do not have the means, then they are left just pursuing other qualifications with a hope eventually to be admitted to the PCLL. It's costly, it takes time, and it's not always effective. So to conclude, our institution welcomes routes which would allow students to actually attempt to qualify.
Okay, do you want to complete? Yeah,
I do, thank you.
Yeah.
So we do agree that academic aptitude plays a large role in the successful performance as a lawyer. However, it's not the sole requirement. So working in the legal profession is a tough vocation. Survival not only requires high level of intellectual ability, but also many other personal skills such as determination, ability to work for long hours, sustained for periods of time, and the ability to maintain a highly competitive drive. This matter should also be taken into account when refining the current system. Additionally, the legal profession has changed quite significantly, whether we like it or not, and it's only natural and logical that the legal education should also be modified to respond to these changes. Now, this is a matter of public interest to ensure that our community has competently trained lawyers who are positioned to cope with the demands of modern society. The changes that we speak of are those that are driven by technological developments, economic constraints, cross-border issues and client demands. The use of technology to enhance the legal services sector is crucial, and this is an area that has plenty of scope. Also, we believe that Hong Kong should focus on its own new unique peculiarities. Already we've noted by the Honourable Mr. Rimsky-Yun that dispute resolution, such as arbitration and mediation, are a main focus in Hong Kong, and we would very much like to see the legal education reform taking hold of those and actually placing Hong Kong as an international centre for those matters. Just finally, I'd like to conclude that we do support change. We believe that reforms in legal education could be a novel way of meeting current and forthcoming challenges to the legal profession that are sensitive to market needs and maintaining Hong Kong's international position and competitiveness. Thank you.
Thank you, Dr. Wilson. 跟住落嚟係我哋嘅同學啊。首先呢，我請香港。
Next, I give the floor to the student representatives. Mr. Maxwell, Hong Kong USU.
On behalf of the Law Association HKUSU, I would like to raise the following concerns over the Common Entrance Exam CEE proposed by the Law Society of Hong Kong. First of all, with reference to the written submission that the Law Association handed in, we have some doubts over the CEE in two aspects, including the necessity and the time of implementation. The association strongly suggests the Law Society of Hong Kong to wait until the release of the report providing a comprehensive review of legal education in Hong Kong, and also to discuss with the Standing Committee on Legal Education and Training on the curriculum of the PCLL program. I understand that the Society is determined to launch the respective exam, and therefore I would like to add on some concerns over the implementation. First of all, I would like to emphasize the fact that current students have little knowledge to the exam. Students are seldom, if not any, involved in formulating the system. And therefore, in fact, it may affect their choices of whether they would be a barrister or a solicitor. And I believe they would like to engage more proactively during the formulating of the draft. Therefore, I would like to inquire about whether the Law Society of Hong Kong would hold public consultations for students in the free universities, such that they may voice out their own opinions and inquiries directly. If the Society finds it difficult to hold such forum, I would suggest the Law Society of Hong Kong to have meeting with the free student bodies representing students that are present today. Hereby, I would like to raise a few questions that students are most concerned with about the CEE. Firstly, could a barrister to be appealed for the CEE when it affects the result of his PCLL examination? Yet the purpose of this CEE is for the solicitors to be, and therefore would it be appropriate for the Law Society to mark the examinations of these barristers to be? It seems more reasonable for them to be regulated by the Hong Kong Bar Association. However, as far as we're concerned, that the Hong Kong Bar Association has no intention to launch such examination. And therefore, when these students appeal for the question, should they approach to the faculty or the Law Society instead? Secondly, are there any exemption for students, for the deferred students in 2022 or as the day is not yet released, will they still be subject to the CEE? I understand that there are still many things that are left unconfirmed. Therefore, we would like to ask for the exact timetable for the release of such information, including the curriculum, exemplar, the drafts, marking guidelines, and all other arrangements for the examination. I understand that there are still many other concerns which I'm not able to include here due to time constraint. And I would like to once again emphasize the association's stance, which is not supporting the implementation of the CEE before the release of the report providing the comprehensive review. And we wish for the Law Society to arrange the aforementioned forum or meeting. Thank you.
Thank you, Mr. So. Next, from Chinese University, the School of Law, Lam Jiqing.
To submit the views of the Undergraduate Law Society. Many of our concerns are similar, if not identical, to those voiced in the previous meeting, as we feel that many of the issues have yet been solved. We understand that a centralized assessment allows students to not have to take 2 sets of examinations, but we are very concerned about the impact of the CEE for students who intend on becoming barristers. A number of undergraduate law society students at COHK have voiced their concerns on whether or not it is fair for the Law Society to set and mark the examination questions when the CEE affects both streams of the legal profession. In addition, it is clear that changes are still being made to the CEE, and for this reason, we believe that the implementation date should be pushed back further, as to not affect current students or those who choose to pursue double degrees or those who will be attending overseas exchange study programs. While PCLL students would only need to take 1 set of examinations, additional burden is put on the students, and there is a lack of clarity on what the final examination will be like. The CEE should not be retrospective, and any amendments made to the CEE should be clearly communicated to the public before its implementation. As of right now, further clarification is still needed as to what the CEE questions will be like, how they will be marked, and exactly how the CEE will be incorporated into the PCLL. We would appreciate if the Law Society continues to work closely with the 3 universities and address these concerns. We are also still awaiting the Standing Committee's comprehensive review, and before further changes are made to the CEE, we believe it is crucial to see whether the concerns raised by the Law Society regarding the supposed inconsistency of the 3 PCLL providers is echoed by the findings of the Standing Committee. Amendments to the current and proposed formats of qualifying examinations for the legal profession should be in line with the findings of the Standing Committee. We look forward to hearing from the Law Society regarding these concerns. Thank you.
Okay, 多謝林同學。跟住呢，我
Next, we'd like to invite City University Student Union Wang Gunwang.
Society opposes it based on reasons that are rather well discussed and mentioned by those who have spoken before me. And mainly, first and foremost, we do not think the installment of power of the Law Society of Hong Kong into the process of selecting of the current process of selecting qualified legal practitioners is necessary, honestly. And that's because I think that power is best invested into the 3 law schools that are currently making the decisions. And as far as I know, law schools have been looking into more holistic approaches into the selection, rather than just looking at the academic result, which is the GPA. And for the Law Society of Hong Kong to just introduce 1 more exam, I do not think it would improve the quality of the selection itself. So that is one concern of ours. And another is that the inconsistency problem that the Law Society is speaking of, as those who have spoken before me have mentioned it, we do not see concrete evidence of it. And we would like to also request that those relevant reports or investigation materials of the so-called inconsistency problem of the PCLL programs be released for the sake of information transparency. And also we may add that the proposal so far is very confusing and unclear to our to members and students. So we would like to add that there should be a more proper channel of releasing the proposals in the future than it is now. Thank you.
好多謝黃同學。跟住落嚟
Next, I'd like to invite members. So, in our first round, we'll set aside 4 minutes for question and answer. The first, Mr. Abraham Shack.
To welcome everybody here. Thank you for coming today to present your views on the legal education. I've not been a lawyer, but I think it's very important that we do have good lawyers in Hong Kong, because Hong Kong being a financial center, the center of Asia, that we need plenty of good lawyers. Madam, I declare I'm a council member of Hong Kong U, representing this Legislature. So basically, I like to ensure that what we are, the PCLL was first started to train qualified and good lawyers. Subsequently, a lot of development have actually overtaken the event. The event is that it's all to be blamed on the government. The government have not given adequate funds to the universities in providing legal education, the PCLL, leading the 3 universities to select the best. Why should they only select the best when there are others, as Dr. Wilson pointed out, that they wanted to be lawyers? Why shouldn't they have a chance? If they can't admit to the PCLL, at least they have a chance to be included into the profession by taking an alternative examination, the CEE. But then the Law Society haven't made very clear the position of CEE. Is it independent of PCLL, or is it parallel to PCL, or is it one of the 2 routes that law students can actually take to become a lawyer? Like the medical profession, when they graduate, they become doctors after training. But in the legal profession, they finish their degree, they might not get a 2-1 or up 2, but they still can be good lawyers. Why you reject them? The Law Society is providing an opportunity for people who have not been able to get into the 3 universities running PCLL. Why should the 3 university becomes the filtration point for the profession? The universities are there to train people. That's the whole purpose. And they are not there to select who is to enter into the kingdom of legal practice. That is something that we have to think about. If the universities have not enough fund, ask the government for the funding. The society needs plenty of good lawyers. We should not deny those young people who wants to be lawyers. Secondly, a lot of people here have vested interests, like the 3 universities. They hold on to the best. They are the only one that can decide on who's going to be the lawyers. But that's not right. If the Law Society wants to instigate a new system, let them. They have the independence to do it. You can bid for it. Like the Edward was saying, that ensure that the university have a critical mass. It's not the university that decide to run on a critical mass basis. The university provide an education. Those education are there to provide good lawyers. If the market doesn't want them, they still can run the university. Like the education system, that we do not have enough students, they close the school. That's wrong. So the purpose of university is to train good lawyers in the days when they first started the PCLL. I fully support that we must have different routes for law students who have been selected to study law, and having graduated from law, they were banished from the legal profession because the 3 universities do not have enough funding to train them. That's a crime.
石禮謙議員頭先提到嘅問題。
The questions raised by Mr. Abraham Shack, that should have been responded. The government, the 3 universities, the Law Society and Bar Association should respond to that. But if they do so, I think it would take a very long time. I'll give you time later on, but in order to discourage members from using all of their 4 minutes, I'll invite Mr. Alvin Young to speak. I'll be quick and direct. I'd like to ask the Law Society, since there was a consultation in 2013 and up till now, how come we don't have any report or any disclosure of the consultation? Do you have any explanation, Law Society? We had considered this request, and the council had decided that there was no need to disclose the consultant report. To put the simple answer is that we had heard these requests, we had convened a meeting, and we do not decide, and we will not disclose this report. Mr. Alvin Young? Chairman, we're talking about entry into the profession and a major overhaul of this process, and the Law Society is has such an important role. I don't understand, and I would like sufficient time for the Law Society why they should explain why it's not appropriate, because they are affecting a lot of people. And it's affecting the whole legal profession. I'd like to understand their thinking, and we'd like the public to understand their concerns. Well, just now, Mr. Abraham Sheikh asked a very basic question, so perhaps, Mr. Hong, you can explain the stance on CE. He seems to understand that CE can replace the PCL, so perhaps you might need to clarify what are you thinking about? What how are you considering the CE, and well, they should be given time to explain what the CE is about. I think it's relevant, and I will give him time. Mr. Hong? Well, I had explained we will not disclose this report, and I apologize. Well, what are the concerns? I know you say you won't disclose the report. In LegCo, when we negotiate with the government officials, they are reluctant to disclose a lot of issues, and I would like to ask the Law Society, could they be a bit more flexible? We have some students here in attendance. Can you explain to us why you can't disclose your consultant report? I will not explain. I apologize. Well, I think Mr. Hong has already responded to your question. Well, if that's the case, I'd like to ask the three universities: are they satisfied with the Law Society? They won't even disclose the consultant report, and then they want to conduct a major overhaul. Can they accept this arrangement? Who would like to respond?
Students, anyone? Indicate yes. Okay. 中文大學嘅林同
See you.
咪好冇啊？
Please speak into the mic.
Undergraduate Law Society, we very strongly need clarification for the CEE because current students have clear to no information regarding what the questions will be like, how they will implement it, and the very core reason of why there is a need to change the current PCLL examinations. All three universities stress the importance of information transparency, and we would very much like for the Law Society to release these reports on why there needs to be a change regarding the PCLL and the CE course and exactly how these changes will be implemented. Thank you.
Okay. 跟住落嚟係
Thank you. Next, Mr. Lam Kwok Hong. Well, Professor Michael Ho from Hong Kong U. Sorry, speak into the microphone. Professor Michael Ho was the first to speak. I had to go to another meeting, that is education panel next door. I listened to him, and he said that in the absence of the review, he doesn't know what he can say. So I've told Holden Chow that perhaps we should have a glass of beer Now for the PCLL, is it going to be there forever? And mustn't we have nothing other than a PCLL? Can we not have an alternative route? We need to have a discussion, but the problem is we haven't got a basis to have our discussion. Now, there is a review. When we have the review findings, then that will form the basis for discussion. Now, for a new system, it takes 20 years, 10 years, 30 years to run it before we can compare it with an existing system. For the CEE, I think the idea can be explored. It can be put into operation. But then for the PCLL, that's the most basic point. Now, it is said that we may introduce something new which can replace it or acting as an alternative. However, we are not presented with any data. I cannot see any reason why we are all here. I think perhaps we should have a drink, Professor Hall. I don't know why we are here to have this meeting. The Law Society doesn't respect us. Mr. Hong has made a point. I think he has said that there isn't any such report and he won't give it to us. So I thank him for being so frank. Well, Mr. Hong, please clarify. I think it seems that everybody is thinking that CEE is going to be an alternative to PCLL. Let's have it clarified so that we have a common basis for our discussion. Since January 2016, on different occasions, I have already explained, well, the Law Society did at one stage want to introduce an independent examination. Law Society doesn't want students to take 2 examinations. Therefore, we consulted the 3 law schools. We try to see if we can make concessions on both sides. According to the last dialogue, I think the 3 law schools would like to take on board our idea that is within the existing PCLL examination in relation to core subjects that the Law Society would like to be included. Then the Law Society will set at least 1 question in such areas, and then universities will also set other questions. My understanding is that within a paper, it is not possible not to allow the university to set questions. So the Law Society will set 1 question, and that question is compulsory, and you have to pass that question before you can pass that exam, and then you can become a solicitor trainee. You can enter into a contract to be trained. In this way, it means that we can dispense with making students sit 2 exams. The overriding principle is that we don't want to make students take 2 exams. I think as of yesterday, I think the 3 law schools believe that it would work. Now, what I want to do now is that we would like to put together a blueprint. If we don't know what we want on our part and we start consulting others, then we can never take it forward. We can never take forward the CEE. Therefore, when the Council of the Law Society has come up with a blueprint, we will certainly consult the universities. Let me say this once again. I'm not a teacher. I don't know whether my idea will work. Someday somebody will come back and tell me that my idea doesn't work, and then I will refine the proposal. So for the comprehensive review from the SC on LET, if they are useful ideas, they will be taken on board. Now for CE, the Law Society will certainly take it forward. Leung Kwok Hong, I allow you to follow this up. I now understand what he is saying. Now for the CEE, well, what he is saying is that when the law schools of universities set the exam papers, now Law Society is saying that it would like to include a question from the Law Society, and students must answer such a question before the Law Society would think it acceptable. Now, I think the Law Society can talk to the law schools. Now, the Law Society governs the members. So, in effect, the Law Society is saying that the existing exam papers are not effective. Now, for the CEE, I think you are also the legal profession. They are the teachers. Now, you're saying that the examination papers are not good enough, and you want them to include at least one question from you. I don't know why we are here having this meeting. Allow me to supplement. Earlier on, we did have a discussion with the 3 universities. The Law Society has tried to balance the interests of the 3 universities. On my part, we have taken the first step forward. We want to try it. We want to see whether it can satisfy the Law Society, whether the Law Society can get what we want. Say, for example, at the end of the day, if we say that we open the exam to anybody, that is, it is not confined to PCLL students, just like what the UK is trying to do. That is, the Law Society would have an examination so that students can become solicitors. This is not impossible, but then for us to make such a big step forward, the change would have been too substantial and the consequence would be too far-reaching. Therefore, to me, the current proposal of the Law Society can benefit from the input from the 3 universities. I think we can have a pilot scheme on such a basis. I've given a bit more time to Leung Kwok Hong. This is because the question of CEE should be given clarification for the benefit of all the members, so I didn't count it towards your time slot, Leung Kwok Hong. Now, I would also like to ask a question. Let me be direct in my question. I don't think it's a matter of whether you're going to include a few more questions in the PCLL examination paper. Now, at the level of the Eligibility, what concerns us most is that currently there are many young students. They have enrolled with the PCL. They have enrolled with the LLB or JD. They have got very good results. They have got very high marks in second low or second up, or some of them have been studying with a elite school, but then they have got a second class B only, and so they don't get a place in the PCLL program. In Hong Kong, you must have a LLB program or JD program before you can get a place in the PCLL program. So it's not a matter of we want to know about your dialogue concerning the inclusion of a few questions in their exam. We want you to tell us about the broad direction for those potential PCL students, existing PCLL students, and students who have been turned away from the PCLL programs. Now, from what members have said, I think they thought that you would like to open up a new route in the form of the CEE. 2 years ago, we had a discussion. It was said that the PCL programs of the 3 universities would not be affected, and you were trying to introduce an alternative route. Somebody might have been a law clerk for 10 years, and he has got a bachelor degree, but he has never got the chance to enroll with the PCLL, or somebody somehow didn't make it in the first year, and he improved in the second year, but he never got a chance to become a lawyer. Now, the question is, we have trained up a group of young people. They have got a law degree, but then they have been frustrated. We want them to get the legal knowledge, but we don't want to have legal knowledge. They have got a lot of money spent on the program to get a JD, or he has spent 4 or 5 years, and yet he never has the chance to sit the examination. Now, in fact, the student representatives did not talk about the complaint. Now, some students are saying that they didn't even have the chance to sit the examination. They would rather sit the exam, fail it, and then they will take it as its fate, and then they won't be a frustrated youth. That's why we have had 2 occasions of discussion. Maybe, SJ, yes, I know the standing committee hasn't released the report on legal education and training. Is a committee led by Justice Chen. Well, we've been looking forward to it for many years. It will be published later this year. We want to know about the progress of the work. If you can tell us what's the difficulty, maybe you are not able to reach an agreement with the 3 law schools. Please tell us why it is so very difficult to have the report ready. Or you can simply tell us that students, indeed, it is very difficult to get PCLL place. So remember that you need to work hard from day one. Otherwise, you will never get to PCL. You need to send a clear message to the market. Tell us what is in your mind. Now, you talk about jointly preparing an exam paper. That's not the focus. You may allow 2 questions to be set by law society. I don't know if the law schools want to take this question. Well, practicing solicitors will also have input on the PCLL papers. Now, I think it is neither here nor there if you start having a question to be included in the exam paper. I give the floor to Holden Chow. Thank you, Madam Chair. I've been listening to the conversation. Both Abraham Shack and Chair yourself have mentioned this point. At first, some of us have this expectation that is perhaps students should be given a second chance. Say somebody has taken the PCLL, or somebody has been turned away from the PCLL admission, but he has experience in the legal profession. He has good work experience, and he would very much like to be qualified as a solicitor. Now, if we are providing an alternative route, it means that we are giving a second chance to him. Mr. Abraham Shack and also the chair have shared this view. On my part, believe Mr. Hong from the Law Society, or paragraph 30 of the paper, it has said that it would not be using the CE as an alternative route, and therefore paragraph 30 of the electrical background brief. So it is said that maybe you should consider those with a certain number of years of legal work experience. You may say that we have misunderstood, or it may be a sort of wishful thinking on our part. We have thought that by having a CEE, you are opening up a second route to those who are interested in the legal profession, so that they still stand a chance to join the profession. And this way, I will encourage it. However, having heard what you said and having read the paper, it seems that that's not it. Well, in this case, it means that lawmakers would be very concerned. And just now, Mr. Hong has spoken. I've listened to him very carefully, and it is said that you have got good intention. However, you don't want to make a drastic change in one go. Now, my point is if there is the ultimate goal that we all share, then can you not expedite instead of making progress at such a pace? I think, in fact, you could have created an alternative route.
So I'd like to know, will you have that consideration? Well, Mr. Hong, from 2016, we have stated this stance on numerous occasions that we want to balance the interests between the 3 universities. The Law Society's suggestion is that I welcome the 4th, the 5th institution. If they want to teach PCL, I welcome them wholeheartedly. The biggest question, and coming back to the CEE, the Law Society if you fail the first time, I can set aside a venue for the people who failed the first time they can be given a second chance. The most important thing I feel is admission. As Mr. Abraham Sheck said, do we need more funding such that students who pass, they can enter the PCLL course? It's only a 2.2 requirement. So I feel the three universities, I think the universities are willing to do so. It's just a matter of money. If the government can open its purses, they can recruit more students. I think to a large extent, to a certain extent, they can meet our criteria. Even though I haven't met any people who say they want to provide a PCL course, but I would hope that they can. There's a fourth or a fifth institute. Each can enroll 60 students for those who failed the PCL examination, but they can have a priority for students or people with experience, and they can have a second chance. I would like to see that. So we will set aside time for a second round of questioning, so you can raise your hand. Paul Jay, Chairman. Even though I've been following this, I am a little bit confused. It seems that we would like to have an alternate route aside from the PCLL. It's sort of like the UK system where they have a bar final. I have been away from law school for quite some time now. I'm not sure what the situation is, but I'm not comfortable. It seems like there's a war between the Law Society and the three universities. The bar is sitting on the side, and they feel that they shouldn't side with them because it affects them. And I think ultimately Hong Kong suffers. The students will suffer, and I hope that no matter what, I hope the Law Society, they might have a lot of problems or frustrations. The universities also need to maintain their standards. They are like the gatekeepers. And we see that there are different standards, and the consultant has been doing its work, and they want to make some small steps. Of course, this pilot program is good, but it's too slow. I think if you look at other countries, the universities should not be gatekeepers to a certain profession. But this is not in the interest of Hong Kong. It's not in the interest of education. I think should we take the view of Mr. Abraham Sheck? Well, the profession should have its say. Where they shouldn't just let it be determined by the university. Mr. Chen Ging-san would also agree that how can the solicitor final affect the bar final? But you have to understand, they can. The bar final and the solicitor final cannot have any impact, and we have the three different universities with differing standards. So, if you find that ridiculous, I would like somebody to clarify it. So, whether if the PCLL is does not satisfy the bar and the Law Society, we need to sit down and discuss. I think you might have some reasons you just haven't been able to disclose that. I think you, Mr. Hong, you have been very fair, but your attitude you give us today is that you're very inflexible, you're not going to compromise, and legislators who are squeezed in the middle. And in my case, I have worked as a barrister and solicitor. I understand we have our difficulties. I had considered some drafting a member's motion dealing with the Chinese name of barrister, and I think we cannot wait for the report. It's been dragging its feet for too long, and I understand you are very anxious now. And just now we heard from Professor Ho from the University of Hong Kong. We need to urge everybody to work a bit more and come to a consensus. And okay, we'll move on to the second round now. I'd like to set aside 3-minute rounds now, and I'd like to give the government some time to respond. I'd like Mr. Rimsky-Yun to respond. I know that there have been some problems with the SCLET. The justice who had to relinquish his post, and I think there's another perspective that you need to consider, not just the profession. You have to look at the society's needs, public interest. And during the consultation, you said you would continue. Who are you consulting? Are you just consulting the legal profession or the stakeholders? You need to consider the future stakeholders. We have a lot of stakeholders, so this is the question I'd like to pose to Mr. Yun. And just now I had a question. Mr. Hong, you were referring to CEE, and you said that there are difficulties in teaching the curriculum, and there are difficulties in setting the CEE test paper, but you need to work with the 3 universities. So how are we going to deal with the concerns, the young people's concerns that I mentioned? I think a lot of people are interested in this topic, and we need to follow up on this. We have a lot of frustrated young people. They might be very capable. They want a second chance. So could you meet halfway? I understand there are interests and there are constraints. So you're saying that you don't want to see 2 tests. But our discussion is about legal education and training in Hong Kong. It now seems that we now have an extra test, people who have already qualified the PCLL, and you're now setting another barrier. Aren't you digressing, Mr. Yun? The DOJ feels that the discussion has been focusing on the Law Society's CEE, the Common Entrance Examination, but our stance is that the comprehensive review, as I said, it should not just focus on one single issue. In paragraph 4 of our paper, we listed the ambit of the comprehensive review. You can see that it's very wide-ranging. We cover the advantages, the disadvantages, the strengths and weaknesses of legal education and training. And we also look at the curriculum of the 3 universities. We look at the curriculum design. So, aside from the PCLL, the LLB or JD, there are views in the society how, for example, how should JD develop, and there are also concerns about standards of PCLL, We also heard the legislators' views, and if we want to develop how do we fine-tune admission to PCLL, or should it be after the PCLL at the exit point? Do we exercise control? We also need to consider the solicitors and barristers, the interface. So for all these big issues, we need empirical evidence, or we need some studies or surveys, and we hope to arrive at a more rational consolidation through our comprehensive review. And my stance is very clear. I would like to see the results of this comprehensive review before we make a decision on the Law Society's proposal of a CE or any other further reform, including whether we should have more PCLL courses, or do we need any other support facilities. Before the report is disclosed, I don't think we should make a rash decision. Mr. Hong, anything to add? My supplement is that I'll defer to Mr. Ye, Mr. Dieter Ye. Well, first of all, I'd like to respond to questions such as Chairman's. The CEE, we have not made it a barrier to the profession. We are not intending to make it a barrier to the profession. The CEE, we require passing a PCLL before taking our test. At the initial stages, we had considered an alternative test. They had to complete the PCLL test first. But after discussion with the 3 universities, after the discussion, we didn't want an extra test. And we explored whether we could have some of our test questions in the PCLL test, and included in the 3 universities' PCLL tests, such that the students didn't have to take another test. So for legislators and the public who don't understand the discussion, currently entry into the profession, aside from having an overseas qualifications, or if they switch from a barrister to a solicitor, aside from that, they have to take the PCLL test in order to join the internship, the solicitor trainee internship. So every year, how many interns do we have? So the barrier is not that with us, it's how many PCLL students graduate. So we have stated for many years that how many people join the PCLL. The Law Society requirement is 2.2 honors program. High 2.2 is the requirement. And how many people surpass the 2.2? And we don't have the statistics. The 3 universities might have these statistics, but each university, on average, in the last few years, their average recruitment and plus applications to the PCLL program, they know whether they reach the 2.2 requirement. If they reach the requirement but are not successful, if they're not successful, can the universities add more PCL vacancies? It's up to the universities.
If universities say that by increasing the number of places they can resolve the problem, then of course it is good. But if they can't, then as Mr. Hong, our former president, has said, perhaps we should consider a fourth or a fifth law school or some other educational institutions offering PCL programs. But again, this is beyond the control of the Law Society. But then if there is such an interest and if there is public support, of course, this can be considered. Mr. Leung Kwok Hong wondered whether we could regard the CEE as an alternative route. Well, as I have said, and in fact the last time I came here, I also made the same point. For the time being, the Law Society's focus is to cooperate with the 3 universities and come up with a common examination. We don't regard it as an alternative route, but then if there is a public request for such, the Law Society will be happy to consider that. Thank you. Next, Mr. Alvin Young. I'm getting more and more confused the more I hear about it. What is the purpose of the CEE? Would it be like what members have said, providing a second opportunity, or whether it is something else, merely to address the point raised in the 2013 paper, that is the inconsistency of standards, so that the CEE is there to sort of align the standards of the 3 law schools. Now, Mr. Hong said that it wasn't acting as a second chance, but then that means that whether it should be 2-1 or 2-2, that's beside the point. So the Law Society wants a CEE. What's the purpose? What's the objective? A second chance, or to align the inconsistent standards among the 3 law schools, which they claimed in 2013, so that there can be a more objective standard? And is there any data to back their comment? Do you have the figures to back up your comment in this regard? Law Society. Thank you, Chair. To answer Mr. Young's question, first, I agree very much with what you have said in relation to the first point. That is, for the CEE of the Law Society, we would like to align the different admission criteria, different teaching methods, and different outcome of the 3 law schools. When the Law Society studied the idea of the CEE, we didn't consider the question of providing a second chance, and we did not regard the CEE as an additional route or an alternative route for admission to our profession. Mr. Alvin Young. Thank you, Mr. Yip. You say that this is to balance, to align their standards. Do you have with you data to say that the standards are really inconsistent? Now, currently, the course programs have not been decided by the 3 law schools on their own. They do have to refer to the curriculum guidelines. So does the Law Society have any data to back up the claim that the standards are inconsistent? Mr. Yip. Thank you, Madam Chair. When we considered the CEE, at the beginning, it was a matter of employer members. In other words, the senior partners of solicitor firms reflected to us that even though students had the same grade from the 3 different law schools, it would be difficult. It was difficult for them to tell which student performed better. Now, we did provide benchmarks for the 3 law schools regarding the PCLL programs, but despite that, it doesn't mean that we're in full control of the programs. Each law school, each university has its own academic autonomy, and they have their own syllabus. they drew up their own programs. And then for the students, well, in fact, for our benchmark, that's only the fundamental requirements. So students need to take other subjects, and therefore the outcome is different. And this is something very basic. For the employers, some of them have mentioned that for a particular university, the passing rate of its PCL program is exceedingly high, while it is quite low in another law school. Now, if somebody has been studying at a law school with a low passing rate, he may transfer to another law school with a higher passing rate, and it appears that he can make it. So it appears that there are inconsistencies. Now, we are the law profession. As far as the entry point is concerned, we are the regulatory body, and yet we are not in a position to have a say as to whether somebody should be admitted into the profession. When the employer members had such a discussion, we found it not acceptable, because we are the law society, we are the regulatory body, and yet we have no idea about the ability of the students. So that's the background of coming up with this idea of a CEE. You can have the third round. I'll give you a bit more time. Fernando Zhang for the first time. Please confine to 3 minutes because we've started our second round. It's fine, Chair. I'm getting more and more confused. Now, the Law Society is a professional body. The Law Society is now saying that for students admitted to the PCLL programs of the 3 universities, it appears that their standards vary, and therefore the Law Society is saying that there should be unification, and so they would like to have a common examination, the CEE. But on the other hand, they haven't given us concrete evidence to say that students' abilities vary a lot. I've been listening carefully to the Law Society. It appears that they have only been relying on hearsay evidence. They were telling us that someone in the industry, someone in the professional has made certain comments. On the other hand, we have the Standing Committee on Legal Education and Training in Hong Kong. They are carrying out a comprehensive review, but it hasn't been concluded. It hasn't been completed. Now, the SJ is saying that we should await the conclusion of the comprehensive review. Now, without getting the findings of the comprehensive review, the Law Society is pressing for the launching of the CEE. Some lawmakers are also asking for the early implementation of the CEE. Even for us in the Eligibility, I still find it difficult to understand. Now, be it solicitors or barristers, if you want to introduce a new entry requirement, and yet you haven't given us full information, and the comprehensive review findings are not yet ready, why are you so anxious? What is the urgency? Can you not wait for a while? Or at least we should wait for the report on the comprehensive review to be published. I think at least you should give us more information, because after all, it is a matter of public interest. I cannot appreciate the urgency. Can somebody from the Law Society explain? Yes. Law Society. Thank you, Dr. Zhang. Let me make it clear. When the Law Society first proposed the common entrance examination, the Standing Committee at that time had not talked about the consultation. Mr. Hong, well, for the findings of the Standing Committee, when they are published, they will certainly be considered by us. When we first tried to consult the universities, at first they didn't want to talk to us. Later on, we said that we were getting serious to launch it, and then it was said that a report should be prepared. I think I'm just telling you the facts. I don't want to elaborate on it. But then that report will certainly assist us in terms of our implementation. So to answer the member's question as to why we have been taking it forward. Madam Chair. For the legal profession and for the judiciary, whether they will have healthy development in the future, I think what we're discussing now will have a far-reaching impact. I'm afraid perhaps the administration has to take a more active role. The government can't be sort of remain in the background. Otherwise, we're going to have another World War coming up. Poor Chair, I think to do justice to the profession and to do justice to the society at large, I think the DOJ must come forward. Both Mr. Hong and Mr. Yip are saying that if nobody is making any progress forward, they would like to take it forward. The SCLET has been very slow. Now that Mr. Rogers is the chair, perhaps things will move faster. As Mr. Yip has said, when you answered Elvin's question, you said that you were sort of trying to introduce an alternative route. At least not at the moment, though we do hope that it will be. You are saying that you simply want to improve the standards, you want to balance the standards, but can you really expect a single exam can sort of align the standards? I need to declare interest. I have the Hong Kong PCLL and I've got a master's degree from CTU. I can understand the plight of students who are in another category. I have to declare I'm also an employer. And I give you some figures to Mr. Yip. If you look at the CVs, if you look at the recruitment letters, we can tell what sort of students we are getting and their caliber. I don't think your CEE can really achieve the purpose. I think you are just trying to do something. So if they can't pass your compulsory question, then do you think it is better? Are you simply asking for something very modest, or you have got something broader behind all such? Well, in the past, many other options have been considered. Say, for example, maybe we should have an examination upon completion of the trainee contract. We considered many different options. Each got its own pros and cons. Say, for example, if trainees only take the exam upon completion of the training, then at least personally speaking, it would be putting too much pressure on the trainee solicitor. This is particularly the case when law firms don't actually have a proper training program. 80% of the law firms are SMEs.
So we can't say that we have a curriculum and you have to teach intern trainees in such a way. So if you ask the interns to take an exam before they can work as solicitors, I don't find it in my heart to be to have such a high demand. Mr. Leung Go-hong, I'm starting to get a grasp of the discussion. You're saying the three universities, you're saying that they're not up to the job. some might be okay and some might not meet your demands, and that's why you're intervening. I think that's going to lead to all-out hostilities. Well, when you do that, it doesn't achieve your goal. How come when you issue a test paper, how does that iron out the differences in standards? Now I start to understand. So, but if you want to create a CE, you want to compete with. So if you have more applicants taking the CE and people who take the CE, they perform better, then you can squeeze out the other tests. But why do you want to do that? And you don't want to disclose the review results, the consultant report, and your expectation and what you perceive, and your expectations are based on what you perceive. We have no idea. You're an employer. Allow me to explain. Let's say a certain subject, conveyancing, the 3 universities, they follow the Law Society benchmark. That subject, conveyancing, the purchase and sale of real estate, what has to be taught is listed, but how they teach it, and when it's tested, what is emphasized. Let me intervene, Mr. Hong. I understand. You're saying that employers have a test and PCL is just a basic course, and essentially they should be acceptable after that test. Well, and if employer says that's not sufficient, then they can set their own tests. Then nobody can stop you from doing that. But the problem is, what you're trying to do is going to make it difficult for a lot of people. You can run it for 5 years and people will take the test. Mr. Leung Go-hong, Mr. Holden Chow wants to ask his question. Mr. Chow, thank you, Chair. I think it's very rare to have such a consensus amongst the different legislators from different political parties. I've been listening to the 2 solicitors explain, and I appreciate the sincerity why they have this idea. But if it's because there's feedback from employers who say that some universities are good and some not so good, well, regarding your first viewpoint, well, we have a free market. The employers can choose. And if you're saying because of that reason alone that you need to intervene, and then you want to grade your own papers, design your own papers, the Law Society wants to make its own test papers, I want to tell you, honestly speaking, no matter how you set the standard, people will challenge you. In a few years' time, the employers will say, why, when we have this standard, do we have the same problems? Is it because a problem with the test paper? And I just want to remind you that might be a possible outcome. You are now drawn into the issue, and if your test is implemented, people will come along and tell you that. And if I'm a student, and when in the future when they take the PCL, they will spend a lot of time on your question. Well, we don't know that. You cannot assume what the students will. You cannot anticipate what they will focus on. This is exactly why this is exactly my concern. As Mr. J said, we can implement our own tests. If I ignore the outcome, let's say by next year I want an independent test if you want to be a solicitor, well, the impact will be very profound. I am gauging all the stakeholders' response, and I'm also looking at the final outcome. I can't control admissions. As I said, I would like to see more students take the PCLL course, but the Law Society has no control over that. And regarding after they exit the test, if we have an independent test, the Law Society can do that. I can fine-tune it every year. It's like my current proposal. If you look at my report in January 2016, I said that we need a review. We really need a review. Can we reach my outcome? I can tell you, I cannot promise you anything. Ms. Alvin Young, did you have a follow-up? We won't object to any reform, but these reforms have to be evidence-based. So when Law Society did a consultation, they used their resources, and they're not willing to disclose that result. I think this is going against the values of our profession, where we want transparency, logic, and so on. I urge them once again: should they disclose their consultant findings? Well, we have a lot of delegations, and some involve law schools. One question is it because of resources? It seems that the Law Society and some legislators feel that it's because the government's funding to the 3 law schools is insufficient, and therefore you will not provide as many PCLL places. So could you respond? Is it really because of money? If the government adds funding, will that alleviate the problem? And second, I'd like to give the government some time to respond. We anticipate the SCLET's report, so could you provide some information? Which stakeholders have they consulted, and when will they finish their report? Can they enhance the transparency? So before December, could you ask the Standing Committee who have they consulted, and is it sufficient to answer the public's concerns? Can it meet our expectations? So you can respond in writing, because next year we will continue to follow up this issue. So we'll now give the 3 law schools some time to respond to the funding question.
Yeah, 3間都答下。
So the 3 law schools could answer in turn.
Issues here, it will take me the whole night to respond to it. But can I just mention one point here, which is that I was very alarmed when the relations between the Law Society and the universities was described as war. Yeah? In fact, we work very closely. Yeah? We have something called the PCLL Academic Board. Yeah? And this board governs everything about the PCLL. Yeah? Whether it's admissions or delivery of courses or examinations or any aspect of the PCLL. So there are many members of the Law Society and the Bar and the Department of Justice, which sits on this board, and all the information, everything is provided to this board. Yeah? And so the avenue is there. We work very closely, and whatever any of these stakeholders, whatever its problems, whatever imperfections it sees, there is the academic board to bring it to. Yeah? And every time, of course, if the Law Society, the Bar, or the DOJ points out a weakness, we take it extremely seriously. And I think that has not been a case where we have rejected any such comments from any of these stakeholders. Yeah. So I would have expected many of these issues to have been dealt with there. Yeah. I speak for HKU, but I understand that there are academic boards in the other two institutions as well, and I take it that the situation is very similar as well there. Yeah.
好，而家請中文大學嘅
We'll now invite CU representative.
I would just add to what Professor Hoare has said. We always want to cooperate with the Law Society.
Can you speak closer to the microphone,
yes,
please?
We always want to cooperate with the Law Society. We remain ready and willing to cooperate in this exercise. It's just that we think that we should really wait for this comprehensive review, for the results to come out, before decisions are made which will affect the public interest. The other matter is, I suppose there has to be a consideration of not just extra places, but we have to maintain a certain quality, and that is for the protection of the public, and I think we should not lose sight of that argument. Thank you.
好，跟住請成
We'll now invite CityU, Professor Ling Feng. Our discussion up till today historically, we have 3 universities, 3 PCLL programs, but it's not run by us. All the programs, we have representatives from the 2 league, from the Bar and the Law Society. They have 2 examiners from the, so they have a quality control role. So if the papers are, even the papers and the syllabus are submitted to them, if they don't agree with the syllabus, it has to be amended. So there is a quality control in this profession. But now I can provide some statistics for you if you want. If you look at last year, the number of PCLL enrollment, it was 783. So there are questions out. So there's an enrollment of 783 from last year. So this is a public policy issue. How many people do you want enrolled? Every year, can we accommodate 783 new entrants? If you want to open the door to more than 1,000, if you look at the numbers in CityU last year, we had 300 plus first applicants. All 3 universities look at first applicants, and they don't look at the second choice. So if you look at the 300 plus first choice, we admitted 170 plus. And they weren't all first choice. So the entrance rate for first choice, it's more than 60%. It's more than 60%. It's more than 60%. So compared to other degree program acceptance rate, it's actually very high. It's not low at all. So should we be like the UK or New Zealand? We have an open door where all applicants can receive legal training, and then we can reserve it for the Law Society and the Bar Association to decide. If that's what Hong Kong society wants, then as a public institution, we're willing to cooperate. No, we don't object. So that's just a policy matter. So we now have 2 thresholds. Do you want to remove both threshold, both barriers? So that's what the Secretary for Justice said. The SCLET, all stakeholders are there. They can discuss it. They can thrash it out. So how do you want the Hong Kong legal profession to develop? How, whether it's the Law Society or the Bar, after discussions, we can coordinate our efforts. we don't have vested interests. We don't have that concern. Thank you, Chairman.
Oh.
Thank you, Professor Lin. Well, there has been a lot of interest in this discussion, but it's time for us to wrap up. As Professor Lin has said, this is, after all, a matter of public policy. We are talking about how we are going to nurture our future generation of lawyers. If somebody has a law degree, does it mean that he must go on to become a lawyer? And then about the number of entrants. Will it be a case of oversupply of lawyers? So, administration, please tell the SCLET and their consultants this request from this panel. When they carry out consultation, the 2 legal professional bodies, the 3 law schools, Xi'an University, students, and others who have studied for a law degree, but they haven't got a PCLL place, or those who have completed the PCLL program but haven't become a lawyer, and then law firms, the business sector, etc. You should consult such bodies, and before completing the interim report, we'd like to get more information. This is because, as we have said, it is a matter of making decisions about our public policies. What is the optimal number of lawyers to be trained? And what are the concerns of the Bar Association and the Law Society? I think we need to be sort of frank in such matters. SJ, I know you are pressed for time. Let me just come up with 4 points in my conclusion. You have asked for some information, like the consultees. Certainly, we will provide the information in writing. Let me take this opportunity to put forward a request. I understand that members were limited by the time available, but then you were all very interested. We have got the law schools, we've got the students. They were also limited in the time available. The DFJ is represented on the standing committee. If anybody would like to have their views channeled to the standing committee, like what you said today, or you may have some other viewpoints in the future, you're welcome to write to us, and we'll be more than happy to act as the bridge and refer your views to the standing committee. Second point, I subscribe to what you have said and what Professor Lin has said, that is, can money resolve all the problems? I think first of all we need to make a public policy decision whether we want to impose a limit on the number of PCL graduates. Then for the PCL program, I think the government has made an exception. Usually, the government would only fund the undergraduate programs. The PCL program is an exception, so it is wrong to say that the government hasn't provided any subvention. And thirdly, for the PCL programs, there's something very special here, because we have got self-funded places. In other words, for the PCL programs, the self-funded places can be something we can consider, though not the only factor. So all the points I have just made are interrelated. Thank you, SJ. Thank you for coming.
Professors, thank you for giving us your precious views. Thank you so much. Thank you, the Law Society and Bar Association. Yeah.
Thank you.
Law Reform Commission. OK， 跟住我哋就進入下一項嘅。
All right, thank you, and we can move on to the following item.
我哋希望呢就係有5分鐘嘅小休，跟住
We'd like to have a 5-minute break and then we'll talk about the LRC reports.